thank you so much for joining us for our free Queensland Thursday webinar. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate, and I'm your host. Strata maintenance responsibilities can often feel like a complex maze. In body corporates, these disagreements are a leading cause of conflict and financial strain. If you face these headaches in your scheme, then please know that you are not alone. Todd Garsden from Mahoneys is here today to help you confidently navigate this landscape and minimise disputes in your community. Todd will break down the legislation and provide practical examples, enabling you to gain crucial knowledge and understand your obligations, thereby avoiding those costly disagreements. We will cover the differences between standard and building format plans, as well as incidental works, the complex areas of utility infrastructure, and the implications of exclusive use bylaws on maintenance obligations. Todd will also focus on common maintenance disputes with examples including leaks caused by Flexi hoses and waterproof membranes, and Todd's insights will provide the practical understanding you need to navigate these complexities confidently. As LookUpStrata does take its transparency responsibility seriously regarding partnerships, I'd like to mention that Mahoneys is a long-time sponsor of LookUpStrata, and also I'd like to mention, as I did at the beginning of the session, that in addition to owning LookUpStrata, I also own Tower Body Corporate. Now, before we begin, I'd like to mention that the information in this session is not advice and should not be relied upon as advice. You should seek independent advice before acting on the information contained in this session. Now, it's really great to have Todd Garsden from Mahoneys back with us today. If you're a regular attendee at our sessions, you would have seen Todd before. Todd is an experienced property lawyer who heads up Mahoneys' body corporate team. Mahoneys was named SCA Queensland's Law Firm of the Year 2023 and also 2024. Todd specialises in body corporate law and predominantly acts for body corporate managers and lot owners. Todd focuses on achieving practical and commercial results for his clients, and he also regularly provides presentations and training on matters affecting the body corporate industry. Importantly, he's also a body corporate committee member, so Todd understands the day-to-day requirements of administering a body corporate. Now, welcome to the session today, Todd. It's really great to have you back with us.
Thanks, Nikki. Thanks for the very nice intro. Today we're talking about body corporate maintenance. I guess the session's probably split into 3 sections. We're covering a bit of an overview of all the principles of maintenance. Then we're going to look at some specific examples that I commonly come across and see on my desk that we've given advice on. And then the last part is going to be your questions. So I'm sure that's probably what we're hanging out for. So we're going to try and get through as many of those as we can. So where I like to start with any maintenance issue, rather than sort of trying to work out who's responsible as step one, is working out what we're looking at. So the 2 main things we want to find out is what survey plan are we advising on and what module are we looking at. So might be familiar with the 2 types of survey plans, standard format plan and building format plan. Used to be group titles plan and building units plan, but effectively the easiest way to think about it is if you're more of the low-rise subdivision, so sort of houses in a community title scheme, you're probably going to be standard format plan. If you're an apartment building, you're probably going to be a building format plan. And if you're townhouses, you could be one or the other. So when you're a townhouse, it's really important to just double check what survey plan we're looking at, because under building format plan, bodies corporate take on more maintenance obligations around the building. The module is also always important to know what we're talking about, because not only are different section numbers, but different obligations that can arise depending on which module we're talking about and different ways that maintenance can be approved. So not a complicated concept, but default position really is body corporate common property, lot owner lot. That's not too hard to get your head around. Where it gets complicated is where there's exceptions, and there's probably 6 main exceptions that we look at excluding. And if we can't fit the issue into one of those exceptions, we're going to revert to the default position. So this is kind of what we like to say as a starting point. So those 6 exceptions are listed on the screen now. So causation I put as number 1, and that's really where the majority of disputes are going to arise. So we talk about that next. Incidental works, there's some very common disputes and well-known disputes about incidental works. Improvements, they shift maintenance obligations Utility infrastructure is probably the most complicated of the six. So we spent a fair bit of time on that issue. Exclusive use, and then, as I mentioned earlier, building format plan changes the rules a little bit. So, as I mentioned, causation is probably where we're giving most of the advice at the moment, and it's when someone else causes damage to something. So, as we're all probably aware, there's a pretty big cyclone that flew through Queensland a couple of months ago. So there's a lot of damage to lots, water ingress coming through from somewhere. So we know that the damage to the lot was caused by something. So if we were just looking at the default position, there's damage to a lot, that's a lot owner's maintenance obligation. So there's a lot of questions about what caused the damage to the lot. So if the cause of the damage was something that someone else was responsible for example, the body corporate not maintaining the roof, then that maintenance obligation of maintaining the damage to the lot can be passed back to the body corporate. So that's where a lot of the advice situates. The key thing for one of these types of disputes is what evidence is there to show that A, the body corporate didn't maintain something in good condition, and B, that failure to maintain actually caused the damage to the lot. So just because water came through a window that the body corporate was responsible for doesn't mean it caused the damage. It means it actually failed to maintain that window. So some pretty common examples here. A car bumps into a common property, knocks the driveway fence over. Pretty clearly the car driver is going to be responsible. Flexi hose leaks, very common dispute, which is one of the case studies we look at in the second part of today. So lot owners are responsible for their flexi hose, it floods their lot and the lot underneath. The lot underneath is obviously going to look to hold the lot above responsible. Someone decides they want to carry out some improvements to their rooftop and they drill a hole through the membrane when they're installing a pergola. If that's caused damage, then they're going to be responsible. And then a common one is owners not maintaining the tiles or grout, which deteriorates the waterproof membrane. So this is all things that shift the maintenance obligation to someone else because someone else didn't do what they were required to. Some examples up here. So we've got body corporate maintaining the rooftop in good condition. The roof leaks because of the hole and then damages the lot underneath. So question is who's going to be responsible for the repair? Obviously because the body corporate's responsible, it didn't maintain the roof in good condition. The water leaked through the roof because of that and it caused damage. So we're going to look to hold body corporate responsible there. Second example we've got there is a gutter body corporate has a maintenance obligation for, but it's in good condition. There was a cyclone that came through. There was meters of rain and the gutter just couldn't cope with that volume of water. Water sometimes backflows from the gutter into the lot, causes damage, and then the question is who's going to be responsible. So this is a little bit different to that first question because the difference here is that the body corporate hasn't failed to maintain anything in good condition. The cause may have been the water flowing from the gutter, but the gutter's in good condition. So the body corporate can't be held responsible for complying with its maintenance obligations. This is just an unfortunate circumstance where because of the volume of rain, there is no one who caused the damage. So the lot owner would then have to be covering the cost to repair their lot. So that's why that one's a little bit different. Incidental works is when you're carrying out maintenance in the normal course, but in doing so, you need to carry out additional works that someone else may be responsible for. So the two most common examples we've got here are tiling works when the body corporate's replacing a membrane. So who's responsible for the tiling? And then if the body corporate needs to carry out some utility infrastructure repairs and needs to cut a hole in a wall or a ceiling or into someone's lot, who's responsible for patching up that hole in the wall? So dispute resolution decision of Esplanade that's on the screen was on that circumstance of a waterproof membrane. So body corporate acknowledged it needed to repair the waterproof membrane on a balcony, but it said to the lot owner, we're not responsible for your tiles, so we're going to put the membrane in and you're going to have to pay for the cost of the tiles. owner quite rightly took that to the adjudicator, and the adjudicator said that, well, no, the only reason those tiles are being needed to be relaid is because the body corporate's carrying out its maintenance obligation over the membrane. So the body corporate needs to remove the tiles to get to the membrane, it needs to also put it back how it found them. So that's why we look at incidental works as an exception, because the body corporate would be responsible for the tiles, even though the tiles are part of the lot. The, I guess, complicating factor in these types of matters is if those tiles were not in good condition, then obviously the lot owner would hold some responsibility on upgrading those tiles so that they were in good condition. Or if those tiles not being in good condition actually caused the damage to the waterproof membrane, then we're actually looking at a causation dispute, which is what we just talked about, where the membrane replacement could actually be passed, or part of it passed back to the lot owner because they caused damage to the membrane. So we've got some examples here, which I may have just spilled the answers on. So we've got body corporate replacing the membrane on a balcony. Tiles are in good condition, need to be pulled up. Obviously, the body corporate responsible for replacing them. That's the first example. Second example is when those tiles aren't in good condition. And the question is, who's going to be responsible for the tiles and who caused the damage to the membrane? So this one isn't as cut and dry. In a matter like this, what we'd be advising the parties is we need to go and get an expert report. And what that expert needs to lay out is what was the damage that the tiles caused to the membrane? So did it accelerate the deterioration? Did it have no impact on the membrane being deteriorated? And trying to apply some level of estimation of what that percentage would be. And then what that would mean is the lot owner may have to contribute some of the membrane costs. We'd also be looking at whether or not the tiles themselves, whether they all needed to be replaced or some of them. And the ones that did need to be replaced would have to be paid by the owner as opposed to the body corporate. So these ones aren't necessarily cut and dry, and it can really show where there's some avenue for dispute and getting some advice on some of these issues, because particularly with membranes and tiles, they're not cheap. So there's some balconies we've advised on, and the cost of replacement across the building is in the millions of dollars. So it's important not just to get it right, but people are also motivated to have a dispute to make sure they're not paying significant amounts of money that they're not responsible for. Improvements is another type of what we class as exception. So if a lot owner carries out an improvement on the common property, default position is that they then become responsible for maintaining that part of the common property. So there is an exception to that, but it requires the body corporate to excuse them from that maintenance obligation. So then you've got an exception to the exception, which flicks it back to the body corporate for common property. So some pretty routine examples I'll put there. So if we've got a lot owner who's installing a solar panel on the common property rooftop, obviously that lot owner is going to take on responsibility for that solar panel. Now, this is probably as a foreshadow, the most complicated issue. A lot of source of disputes and a lot of misunderstanding across the industry on this area. So we spent a bit of time on utility infrastructure. Now, when we go back to our starting point and trying to apply whether an exception exists, and we try and work out whether the item is common property or part of a lot. Now, what Section 20 of the Body Corporate Community Management Act says is that all utility infrastructure in a scheme is common property unless an exception applies. So when we're looking at utility infrastructure, even if it's within a lot, within a boundary structure on the common property, no matter where it's located, the starting point is that that is common property. Then we look at some of the specific utility infrastructure exceptions to see if it is actually part of a lot or owned by someone else. So when I say owned by someone else, sometimes a developer or even the body corporate enters into an agreement with a third party, whether it's a telecommunications provider or something like that, where that infrastructure will not pass to the body corporate. So it doesn't get captured by Section 20. So that's not really the source of dispute. The source of dispute is whether or not it ticks those three dot points in the middle there, which is that it only supplies utility services to a lot, is within the boundary of a lot and not in a boundary structure. Now, this exception commonly gets misconstrued to be a maintenance obligation issue. This only determines if the utility infrastructure is common property or part of a lot. It doesn't determine who's responsible, because as we've just looked at some of the other examples, ownership of something does not always mean maintenance obligation. That's why there are exceptions. So this first slide is only determine the starting point. Are we looking at common property or are we looking at part of a lot? Those three dot points commonly get mixed up with the maintenance obligation, which is what this slide's about. So if we determine that that utility infrastructure is part of a lot, then obviously the lot owner is going to be responsible. But if we determine that utility infrastructure is common property, it doesn't always mean the body corporate is still going to be responsible for maintaining it. And this is where this exception really comes into light. So if we determine the utility infrastructure is common property, the maintenance obligation can still be put on the lot owner, even though they don't own the infrastructure. And it needs to meet these two thresholds. Again, it needs to only service that lot. So if it services more than one lot, it remains body corporate obligation. But even if it services one lot, it still needs to fall within one of those categories of A to G. And this is where it gets quite complicated, and why I've underlined, italicized, bolded, and put red the word device. That's what we're always looking to argue around. So if we've got a piece of infrastructure, it is common property, but it's only servicing a lot, it's still not going to be the lot owner's obligation unless it's one of those A to G items. And the one that always gets a little bit complicated is, what is a device? It's not the most straightforward answer, and there's some almost inconsistent decisions on the point. But there's been some recent guidance that were involved with a scheme down at Coolangatta that I think really helped clarify what this means. And the way I have tried to reconcile it in the most basic form is basically something that you can turn on or push a button on. So what I talk about that is, a gutter is not a device. A gutter can't be turned on, there's no button to push, it is just utility infrastructure. That's not going to be something that passes to a lot owner to maintain. A toilet has a flush, that's a button. That's going to be a lot owner device. Air conditioning, although it's already mentioned in E, that's a device. It's something that turns on. So we're looking at those pieces of infrastructure which have a button or a function. They don't just exist like a gutter. The other source of dispute is, even if we've identified a particular device, so let's say it's a grease trap, we look at the infrastructure that's attached to that grease trap. So obviously it's got waste lines running out of it. Sometimes those waste lines connect in with other sewage lines or other waste lines or grey water or whatever it might be in the scheme. So it's really important to understand what the specific piece of infrastructure we're talking about maintaining is, and whether it itself is in good condition. So if we're looking at the grease trap itself, it's pretty straightforward. If we're looking at one of the waste pipes that flows from the grease trap that has another evacuation pipe that connects into that, are we now servicing more than one lot, and we lose that first part of the exception because it's servicing a toilet up on level 4. So that's this, as you can see, this is why this one's probably the most complicated. So if we look at some of the more straightforward examples, we've got a pipe only connected to one toilet, but it's associated with that device. The pipe cracks and needs to be fixed. Obviously, the lot owner who's being serviced by that pipe is going to be responsible for maintaining it. We've got electricity cable from the main switchboard, and that switchboard services multiple lots. That cable is damaged and needs to be repaired. Now, who's responsible for those cable repairs? Now, this might seem like a relatively straightforward question. It's going to be that lot owner. But there's some discussion around this point about the way that the electricity flows from the transformer to the switchboard and whether it's upstream or downstream. So is that cable, which is downstream from the switchboard, assisting just the one lot, or is it associated with a broader infrastructure across the scheme? So this was basically a case study in a recent adjudicator's order that effectively found that the cable that runs between those two items directly to that lot, even though it was broken and it didn't affect any other lots, the body corporate was responsible because it was effectively downstream from a device that serviced more than one lot. So as you can see, it's sort of mini exceptions to existing exceptions, and it gets quite complicated. And then we've got our standard gutter exception example down the bottom, where the gutter on the common property only serves as a single lot. So the error sometimes people assume is that the lot owner is going to be responsible, but it's common property and it's not a device. So the body corporate's going to remain responsible for the gutter. Building format plan is, as I mentioned at the beginning, a really important thing to understand, because even though we've got the default position, under this plan, the body corporate takes on a lot more of the maintenance obligations across the building. So they're listed there. There's 6 things. So I've split them into what needs to be maintained in good condition and what needs to be maintained in structurally sound condition. And as you can see, I've underlined that that does not mean good condition. So when we're looking at structurally sound condition for the foundation structure, roofing structures, and supporting framework, that doesn't mean that we need to make sure that, as in the body corporate doesn't need to paint a roofing structure to make sure it's looking good and the paint isn't flaking. If that's part of a lot, that's a lot owner's obligation. However, if that roofing structure is not structurally sound, it's leaking water, it's rusting, it's going to fall over, then that is a body corporate maintenance obligation to make sure it's structurally sound, not looking good. So for those types of things like essential supporting framework and roofing structures, the maintenance obligation over that item can actually be shared between the lot owner and the body corporate, but for different standards. So we'd have, let's say it needed to be completely replaced. We'd have the body corporate paying for the structural repairs, and we'd have the lot owner potentially paying for the cosmetic repairs. So making sure that those maintenance obligations are appropriately split and costed is really important. So one party is not paying for things that the other party should be responsible for. The other item I've highlighted there is providing protection. So when we're looking at roofing structures, obviously a roof is pretty clearly within that definition. But what isn't always clearly in that definition is balconies and sort of awnings and things like that. So adjudicators have determined that balconies, so external balconies, are a roofing structure for the lot below, and therefore get caught up in the body corporate structural maintenance obligations. When we've got sort of awnings and things in a courtyard, they are a roofing structure, but there's a question about whether or not it actually provides protection. So protection to me can mean a number of things. It doesn't mean absolute wind, weather, sun protection. It can sometimes provide protection for falling objects. It can provide filtered light protection, even if it doesn't have a firm cover over the top. So they're the types of things that commonly get disputed about whether a roofing structure on a balcony, like a pergola, is actually providing any protection to that lot. And then we have the same argument about whether the repairs required to that item are going to be structural or cosmetic. So that's why building format plan is really important to understand and identify right at the beginning, whether it's BFP or standard format plan. So we've got some quick examples here. So we've got paint on a structural beam. Who's going to be responsible for that? It's within a lot, and it's going to be the lot owner, because that's not a structural issue. It's a cosmetic issue. We've got a balcony door opening from a lot's inside to the outside and needs replacement. That's going to be the lot owner's problem. It's within their lot. and then pergola on a podium balcony needs replacing. That's potentially going to be split between the structural elements and the cosmetic elements. The last example that we've got on our list is exclusive use. Again, this is something that's actually quite commonly misunderstood. So the default position is set out there, which is if the bylaw doesn't say anything, then the lot owner is going to take on a responsibility for maintenance and operating costs. In a BFP, the body corporate maintains those 6 items we looked at on the last slide. But what adjudicators say is that when there's any type of reference in that bylaw that talks about maintenance, that is the absolute extent of a lot owner's maintenance obligation. So the most common example is where an exclusive use bylaw says that the lot owner is responsible for maintaining the exclusive use area in a clean standard. That means the lot owner only needs to maintain that area in a clean standard. It is not responsible for the rest of the maintenance and operating costs, and that falls back to the body corporate. So sometimes when a bylaw unintentionally tries to put in a maintenance obligation of the lot owner, it can actually have the opposite effect and take away all the other maintenance obligations that would have otherwise had if it just stayed silent. That's very often misunderstood. As I mentioned earlier, there's also the BFP exception. So the body corporate continues to maintain the structural elements unless the bylaw specifically says otherwise. So if the bylaw said that the body corporate, that the lot owner must maintain the structural elements of the exclusive use balcony, then it must do that, but it doesn't take on the balance of body corporate obligations for the essential supporting framework. So in both of those circumstances, you interpret them to favour the lot owner to the body corporate's expense. Is probably the cheat sheet of how to interpret them. So the example on that point is we've got a silent exclusive use bylaw, says nothing about maintenance, and then the question is who's going to pay for the lighting of that exclusive use area. That's an operating cost, but because the bylaw is silent, the lot owner must pay for those costs. If the bylaw says the lot owner must pay for the painting of an exclusive use area, it only needs to pay for painting. It doesn't need to pay for any other type of maintenance. That is now back to the body corporate. And then the final example, we've got a BFP exclusive use area. The bylaw says that the lot owner must keep the roofing membrane in good condition. The lot owner must maintain that roofing membrane in good condition, but it doesn't take on any of the other BFP exceptions that the body corporate is otherwise responsible for. So that's, I guess, the first part of the presentation. This is the second part, which is going to look at some of these examples quickly before we can jump into Q&A time. So waterproof membranes, as mentioned earlier, are really common source of dispute. So actually, a lot of people don't understand what a membrane is, and it's actually more like a paint layer, a flexible paint that sticks on a surface and is like a stretchy drying type product. It's not actually like a thin tarp that gets applied. So membrane is probably a slightly misleading way to understand it, but think of it as more like a stretchy waterproof paint that goes in between layers to basically have water run off. So if there's gaps in that paint, obviously the water is going to find its way through, and that's a really common maintenance issue because membranes unfortunately have a finite life. They don't last forever. I think in a building that I'm chair for, we were hoping our membrane would last 10 to 15 years, and it went kaput after 8 years. We need to pull out all the tiles, put new membranes down and put back all the tiles. Obviously quite an expensive job, but needs to be done. So because they're so expensive, as I said earlier, it's a big source of dispute. So if we're going to look at who's responsible for replacing a membrane, as I said at the beginning, we start with, are we standard format plan or the building format plan? Standard format plan is easy. It's going to be the lot owner's problem. It's going to be part of their lot, and there's no ability to pass that on to the body corporate. It's really building format plans where this is disputed, and there's a bit of misunderstanding where if we see membrane and building format plan, we automatically say, oh, that must be the body corporate's obligation, but that's not always the case. So if we look at the exceptions that we just went through, we always say that the lot owner is responsible for maintaining their lot. So if there's a membrane within a lot, starting position is the lot owner is responsible. However, one of the exceptions is that the body corporate will take on maintenance for roofing membranes that provide protection for lots or common property. And obviously the body corporate will be responsible for maintaining common property. So those two things that we've underlined are the two things we need to identify if we're going to make the body corporate responsible for a membrane. So if we look at one of the membranes in a lot, let's look at the bathroom membrane. So this doesn't meet those two things that I'd underlined, because a bathroom membrane is not a roofing membrane. The bathroom of a lot is not a roof for another lot. So there's a decision there, the Dalgety, which confirms that position. So bathroom membrane is going to fall back to the lot owner. If we look at balconies and rooftops, that's a little bit different. So as I mentioned earlier, rooftops are a roofing structure, easily body corporate, and balconies are a roofing structure for the lot below. So that, again, allows it to be placed on the body corporate. But the one thing to not get tripped up here is it still needs to provide protection. So if we're looking at a ground floor unit, we need to make sure if there's anything underneath that ground floor that it's providing protection for. So if we're ground floor unit of a BFP and there's no common property car park or anything underneath that balcony, it's not a rooftop and it's not providing protection to anything. So that lot owner on the bottom was probably going to be responsible for their membrane in their courtyard or balcony, whatever it might be. So we've still got to make sure we tick the boxes of those exceptions. We don't just apply a general rule about, oh, it's a membrane in a balcony or a courtyard, it must be the body corporate's problem. A very common place of dispute for membranes is when there is no membrane. So I think the requirement to install membranes on balconies only came to exist in the last couple of decades. So there's a lot of older buildings that actually don't have waterproof membranes installed in their balconies. Just because that's the case, it doesn't mean the body corporate needs to install one. It can't have a maintenance obligation over something that doesn't exist. So that Bayview Tower decision confirms that body corporate doesn't have a maintenance obligation to install a membrane because there is no membrane. You can't maintain something that was never put there. It doesn't mean they can't be obliged to install one in certain circumstances, but it's not going to be because of their membrane obligation. So if there was evidence that the lack of membrane was going to cause a structural issue to the building and going to cause damage to the foundations, then the body corporate would be obliged to install the membrane. But that's not because of its membrane duty, because of its obligation to maintain the building in structurally sound condition. It's just a function of that discharging that duty, just happens to be installing a membrane. And that's what Sanctuary Gardens there talks about. So that distinction, again, commonly source of dispute and commonly misunderstood. So the reason for that is we need, if we want to make the body corporate responsible for installing a new membrane, we need to identify one of its other maintenance obligations. So the most common one there is maintaining in structurally sound condition the foundation structure, but it doesn't mean that's the only one. So if you had a report that said if the body corporate doesn't install the membrane, it's going to cause damage to the doors, windows in a boundary wall, then that would also create an obligation on the body corporate to maintain, to install the membrane. But it's not going to be because of the membrane example, it's going to be because of the doors and windows example. This, again, when we're talking about waterproof membranes, we always revisit the Esplanade decision we mentioned earlier, which is the ancillary works exception. And along with that comes those ancillary considerations about, well, what condition were the tiles in, what condition was the grout in, are we going to share responsibility with the lot owner, and if so, in what proportions? And it's always going to come down to expert reports. membranes are a really good example for a lot of these exceptions, because we can also look at incidental damage and causation, because if we have a failed waterproof membrane, the water is going to go somewhere and it's going to end up in a lot at some point. And we know that water in a lot is going to cause damage. So if we've got a failed membrane and water is ingressing into the lot underneath, then unfortunately that body corporate doesn't just have to fix the membrane, it needs to fix all the damage that was caused by that failed membrane. So again, this is why we talk about the general rules first, and then look at how it can be applied to these examples. And there's provisions in the legislation there to go to the Commission's office and get orders, not only compelling the body corporate to repair the membrane, but to also reimburse lot owners for repairs they've had to carry out. So if they're patching walls because of the water damage, and also to require the body corporate to send a contractor into the lot and fix the walls if the damage hasn't been repaired yet. So you can see that the liability can ramp up pretty quickly when maintenance obligations aren't being complied with. The other big source of common examples is Flexi hoses. They burst all the time. Always say, get them checked. And one of the case studies we're about to talk about talks about bodies corporate trying to actively manage that. So we know Flexi hose is a lot owner responsibility because it's part of the lot. If we look at that provision of Section 20 of the Act, it doesn't form common property because it's wholly within the lot, services only that lot, and is not in a boundary structure. They're all within normally the cupboard of the laundry, which is where they all seem to burst. Similar to waterproof membranes, they have a finite life. They fray and they always seem to burst at the time when no one's at home, and then it'll flood for 3 days and cause hundreds of thousands of dollars to the building. And that's a provision here of when a lot owner doesn't maintain something they're responsible for and it causes damage to someone else. Unfortunately, that lot owner is responsible. It's not actually a body corporate problem. So Soleil, which is one of the big Meriton buildings in the city here, it actively wrote to all its owners on a regular basis and told them, hey, there's Flexi hoses in all your lots. Flexi hoses are prone to break. We've already had some break in the building. You should go and check your Flexi hoses and replace them if needed. Here are some contractors that we've arranged to give you a good deal on doing that. You should contact them directly. Body corporate doesn't have to do that. It doesn't need to remind owners what their statutory obligations are, but it was trying to be proactive. Despite that, I think within 2 months of sending out one of these letters to the owners, there were 2 owners within a week who both had burst Flexi hoses, and not only damaged their lot, but damaged a couple of lots underneath and also the common property. Insurance claim was made, and luckily the insurance covered both of the damage and repaired it all. But obviously there's going to be an insurance excess. So the lot owners challenged the body corporate imposing that insurance excess on them on the basis it was unreasonable. And it was, and they also complained that the body corporate didn't provide them enough notice that they specifically had defective Flexi hoses. I would hope that the outcome isn't too unexpected to those, but what the adjudicator said was that just because an insurance excess is expensive does not mean it's unreasonable. I think it was $10,000 on both occasions. And the position I always remind owners of in this is, if it wasn't for the body corporate's insurance policy, you would be paying $10,000. You'd be paying the $100,000 of damage that was caused because of your failed maintenance obligation. So you're not out of pocket $10,000, you're actually saved $90,000. That point doesn't always hit home. But this is what the adjudicator said. Not only was that insurance excess quite reasonable, even though it was expensive, but the body corporate doesn't have an obligation to actively go and tell lot owners you should be doing your statutory maintenance obligations. And the adjudicator, I think correctly, was quite critical of that owner to even question it when they had actually taken active steps to remind owners. They didn't need to go any further than that. They actually didn't even need to do that at all. So it was quite a sensible outcome for both those lots. So there's a lot of concepts we've just gone through. Take the next slide with a grain of salt. It's to do two things really. It's tried to summarize all the things we've just spoken about, but it also is a good demonstration of how complicated some of these issues can be. So this is something that I've worked up over probably the last decade and had, I think this is version 4, and each version seems to get a little bit more complicated than the last, depending on what adjudicators' orders have come out recently. But it's helpful as a guide to try and get most often than not the correct answer. But it does utilize the default position. It utilizes those 6 exceptions. And you're welcome to use it to try and get a sense of who may be responsible. But don't use it as gospel, but it should be relatively helpful to try and work out some of those issues and work out whether or not those exceptions do apply. So that's the second part. I think Nikki might have some viewer Q&As lined up for us.
Is there a simple who is responsible document available to all strata owners as there is in other states? And then I've just added to that, if not, why not? And I think you've covered that in that last flow chart that you had out in the presentation.
Yeah, I mean, I wouldn't say it's simple. That's just something that I've come up with. But the Commissioner's Office website, obviously part of the Commissioner's Office is dispute resolution, but there's also got a big element of education. And their website does have a lot of information on there. Again, use it as a way to get a sense of who is likely to be responsible. It's not going to always apply to your specific circumstances. So there's no simple document because it's not a simple issue, but there is a lot of resources available.
Excellent. Okay, that's great. Thank you. And then we might just do a quick Q&A, which is some of the questions I picked up that we just like, who's responsible for this, who's responsible for that. So one of them was the water isolation valve was mentioned.
Yeah, isolation valves are one of those examples that fall into that question. Are they a device? So if that's one that can be switched on or off, then to me that is a device. Yeah, it's just got to check that it still hits the box of all the other exceptions. So it doesn't somehow service more than one lot or bit of the common property, and making sure that it is connected to the one lot. So normally it is a lot owner responsibility, but sometimes there are some disputes around what is the utility service that it provides. So as long as it's, if it's a water supply isolation valve, then that typically will be a lot owner responsibility.
Okay, wonderful. Thank you. Also, we were asked about intercom handsets in the lot, and that was in a building format plan.
Yeah, and that talks about that point when we're talking about utility infrastructure, about what part of the intercom is broken. So is it the handset part within a lot? That's going to be the lot owner obligation. But if it's one of the connection lines or the copper lines that goes back a level, because obviously they tear off from a common line that services more than one lot, and then there's going to be a part of the line that only services the one lot. So it could identify which component of the system is in good condition, it is not in good condition, and then whether or not that component connects just to one lot or connects to more than one lot.
Okay, wonderful. And also similar with a building format plan, a garage door openers, the motors.
Yeah, that's a really good example. And again, it's going to depend on whether or not it is part of the lot. So if the car park itself is part of the lot, and then the other side of the garage door is common property, then that falls into the exception of the body corporate that makes them responsible, because it's on a boundary structure and it's one of the components, and that includes the roller door and the motor for that. But then when you look at if it's an exclusive use allocation car park, we've got to then look at what the exclusive use bylaw says to see if that changes the position, because it can make the lot owner responsible.
Okay, because we were also asked about doors and windows opening onto an exclusive use area, which I assume would be a balcony type area. So is that the similar situation for that as well?
Yeah, so it's probably going to be lot owner, but it's going to depend on exactly what that exclusive use bylaw says.
Okay,
If the
wonderful.
door and if the door and window is wholly within a lot, then it's always going to be lot owner.
Okay, wonderful. And then we were just asked also about pest control.
Yeah, that's always a common dispute. So obviously over the common property, body corporate is going to be responsible, so it should be getting its pest control out. But lot owners are responsible for the pest control within their lots. So when there's a dispute about damage caused by pest control, termites is probably the most common example. If that termite nest can be identified as originating from a common property or originating from another lot, the body corporate or that other lot owner can be held responsible. But again, it's going to come down to the evidence of causation about whether or not you can identify where that termite nest originated from.
I'm an owner in a body corporate. I'd like maintenance carried out on our front windows, such as renewing the frames and installing tinted glass. Is this my responsibility? If so, what approvals are required? Are there planning restrictions? And as the work encroaches upon common property, what do I need to provide?
I suppose the first point here is if we're renewing frames and installing tinted glass, that sounds like an improvement rather than maintenance. An improvement has vastly different rules than maintenance because there's no obligations to improve. So if the lot owner wanted renewed frames and tinted glass and it was an improvement, then they're the ones who are going to be responsible if that's what they want to happen. If their maintenance was required, as in they weren't in good condition and we wanted them to be repaired like for like, and it sounds like it's on a boundary between common property and a lot, then it would be body corporate responsibility. So in this circumstance, if they are not in good condition, but the lot owner does want an improvement, you can reach out to the body corporate and say, let's get a quote for the repair, but I'll pay for the increased costs for the additional improvement works. And then you need to also get on the same page about future maintenance because the lot owner will probably become responsible for it unless the body corporate decides it will keep maintaining that window.
Okay. Do insurance companies understand the need for contents insurance that covers things like repairs, maintenance, replacement of a door that opens to a patio, which is within the boundary of the lot? And I thought that was an interesting question because it brought in the fact that insurance companies understand the complications around maintenance in strata buildings.
Yeah, and I think this is, again, a very misunderstood part of the industry. So it's not about insurers needing to insure things for owners. The legislation says what a body corporate insurance policy must have. An insurer doesn't really care what it's insuring for. It will price the insurance risk accordingly. So there's not a need for body corporate insurers to insure contents of a lot because the legislation doesn't create that need. An insurance policy will cover whatever is agreed upon between the parties and in the terms and conditions. So it's more probably about lot owners understanding the extent of the insurance policy that the body corporate has and making sure that they go on to insure anything they want insured that it might not cover. I think the other seeming misunderstanding on this point is that insurance policies don't cover maintenance. Insurance policies cover events. So they will not indemnify a body corporate because something they were required to maintain wasn't in good condition and needed repair. That's the body corporate's cost to repair it. What it will cover is if a storm rolls through and breaks something, it will fix the breakage.
Okay, thanks, Todd. In Queensland, can a body corporate use body corporate funds to paint the walls and soffits of either the balconies, patios, or courtyards which form part of a owner's lot, or exclusive use areas which the owner is required to maintain in good condition under the exclusive use bylaw? And if not, is the body corporate allowed to include the cost of this private painting in the lot owner's annual levies, for example, through the sinking fund?
Yeah, this is a really, really good question and almost a bit of a bugbear of mine. So there's a number of different elements to this. So to answer the direct question, yes, the body corporate can use body corporate funds to paint things that lot owners are responsible for, but it can only do it on two very specific circumstances. And both of those circumstances involve recovering those costs from the lot owner. So the first example is when you've got a big painting project, the body corporate wants to make sure everything within the building is done, and that includes things that the body corporate's responsible for and things that the lot owner is responsible for. What should happen is that a service agreement is entered into between the body corporate and each lot owner to engage the body corporate to basically procure those works for them. And there's a lot of reasons why that would make sense, because getting one contractor in to do the whole building in one go is going to be a hell of a lot cheaper than every lot owner engaging their own painter. Works are going to be different standards. It's going to happen not at the same time and for those practical reasons. But what the legislation says when you do that is that the body corporate must recover the costs from that lot owner that relate to the work carried out to the lot. So it shouldn't be funded ultimately by the body corporate for the lot owner's work. It should be funded by the lot owner. In terms of budgeting for it, I mean, you can budget for it because obviously the body corporate's going to be paying out those funds in the first instance, but you'd be recovering that same cost from the lot owner. So it wouldn't necessarily make sense to budget for it as part of the levies and then recover it from the lot owners anyway, and then you'd have to do an adjustment. So it should probably be a separate line item on the income statement that says owner recoveries for painting works, and then it would have an equivalent outflow in the expenses for those elements of that contract paid for the lot owner work. The second circumstance is when the lot owner is basically refusing to carry out the painting works they should be, and the body corporate goes and does it on their behalf, and then it basically recovers the cost and sues them for that work. So in any circumstance, body corporate shouldn't be paying for maintenance obligation to the lot owner. It can do it, but it needs to get those costs back somehow.
Okay, thanks, Todd. And we just asked clarification on that. Is this comment specific to building format plan or also standard format plan?
All types of buildings. So whether it's painting a soffit, I mean, that's going to be, I think this example was building format plan, but the principle applies to anything. So in a standard format plan, a common one is mowing front yards that are part of the lot. It's the same principle, that those costs should be recovered from the lot owners.
Okay.
Must be recovered from the lot owners.
Okay, wonderful. And is there a case? There's a case about this particular question that we might be able to send a link out to everyone. Is that correct?
Yes, there's plenty. So we can put that together after. I think there was quite a recent one at building Sunny Coast called Waves.
Okay, wonderful. All right, we might send that out. There are a couple of other, while we're on that, there are a couple of other cases you mentioned. There was, with regards to devices, there was a Coolangatta case, and also with electricity flow and adjudicated order. So we might send the links out to those as well if we can. That'd be great. I'm sure people would be interested to have a read of them. We also asked who's responsible for a dropped ceiling and the downlights in the dropped ceiling when this has been installed by a unit owner.
Well, I mean, it sounds like it's part of the lot. So starting position is lot owner. And then it's a question about, well, what caused the drop ceiling? If it just dropped for whatever reason and we can't identify something another party was responsible for it, that position's not going to change. But if it dropped because there was water ingress from a rooftop that had a fouled waterproof membrane, then potentially we'd be looking at the body corporate, but we need to know what caused that dropped ceiling.
Okay. And a lot owner undertakes balcony repairs themselves. They remove the tile and install waterproofing membrane and replace the tiles. They install a pergola and the bolts penetrate the waterproofing membrane. Water is leaking into the unit below due to the poor workmanship of the owner who installed the waterproofing membrane and due to the bolts having been installed and penetrated the membrane. Waterproof membrane is the responsibility of the body corporate. Does the responsibility of this transfer to the lot owner due to the work they carried out without body corporate consent?
Yep. Yeah, and that was, I think, one of the examples we looked at, and there's a few different reasons for that. Obviously, there's an improvement exception, and there's also a causation exception.
If an owner has solar panels installed on a roof without body corporate approval, do the solar panels become an asset of the body corporate? And if so, do the solar panels now become the responsibility of the body corporate to maintain?
Yeah, that's a really good question. So we look at that section 20 about what determines common property, and yeah, that's utility infrastructure within a scheme, and there's no agreement there to make sure that ownership does not pass. So that is now common property. The maintenance of it, though, can still be managed quite easily because you've got an improvement to common property by a lot owner. So there's the improvement exception. We'd also be looking at, if we were advising that body corporate, of writing to the lotto and saying you've got an unauthorised improvement, either get rid of it or seek approval. And one of the conditions of approval would be that they become responsible for that ongoing maintenance.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.